Welcome to Peas in a Podcast. If you've ever thought, why didn't somebody tell me this before I started running my business? You are in the right place.
Each week we unpack the human stuff that makes or breaks your business without the corporate wank.
And this week we are talking about legal risks in recruitment.
And this is a big one because...
I thought you were going to make some sort of degrading comment about how it's one of your least favourite subjects.
I was really trying not to. No, I'm going to give this the clout that it rightly deserves.
Excellent.
Because our clients are always trying their very hardest to make sure they're fulfilling all of their obligations with their employees, or at least seeking advice when they're not sure. Mm-hmm. But what's really interesting about this subject, and I use that term genuinely and authentically interesting, is that actually perhaps what they don't realise is that the risks and the legal concerns start before they're even ready to employ somebody, at the point perhaps they realise they're going to be taking someone on. Is that right?
Absolutely. I think even before you become an employer for the first time, and we work quite a lot with clients who become employers for the first time, and they want to make sure that they're getting it right from the outset. You inherit employment law obligations from the minute you advertise for a role, right? Mm-hmm. So, and when we talk about legal risks in recruitment, it's probably one of those, like you said, more unknown areas, and the different types of legal risk spread across different legal provisions and different areas of law. So sometimes it's quite hard to get a good grasp of what are some of those key kind of legal considerations when you do decide to run a recruitment drive to recruit somebody.
And what's really interesting is that we run recruitment drives fully managed, and we do that because there are some organisations that go, okay, I know that there's some things I need to be concerned with, or I've been challenged previously. And then we've got others, and I'd say there's quite a number of these that don't see recruitment as a HR process because perhaps they think, well, I've been through a recruitment drive myself. How hard can it be? I've just got to chuck an advert up on Indeed, and then I'll get some CVs through, and then I'll see who takes my fancy, and I'll give them a call and bring them in for a chat, and then at that point I just need to issue them a contract and get them started, and it feels like less of a deal than perhaps it actually is.
Yeah, absolutely. And we've covered this in a podcast previously around the effectiveness of actually being able to recruit the right person that's likely to sustain and thrive in your organisation. But this week we're coming at it from kind of the compliance aspects of it and making sure that you do it in a safe way to avoid any potential legal challenges, allegations or loopholes that you may come across. Effectively, you don't know what you don't know. So let's crack on.
So when we're talking about don't know what you don't know, for people who are sitting there thinking it's not risky and I can do it myself, what would you say the key risks kind of as a whole that they need to be concerned with are?
Okay, so the key, I would say, overarching legal risk is around discrimination, right, as coined by the Equality Act, which places the provisions of which place an expectation on employers to ensure they're not discriminating against potential job applicants when in three areas of the recruitment process, either in the terms by which they would like to offer the role, the arrangements by which they make a decision on who to offer the role to. So in simple terms, the assessment process, shortlisting, sifting, interviewing, all of that, and the decision itself as to who to accept or who to offer the role to, So they're the three areas that the Equality Act is concerned with ensuring that employers act appropriately, fairly, and make decisions that are non-discriminatory by nature.
So there's two things, and I don't know, you tell me which direction to go in, because I think that those three are actually really helpful in terms of being able to break this down. So the terms, the assessment process, and the decision. That's actually probably quite a helpful framework to be able to have the rest of this conversation. But so we can do that. But should we talk about the characteristics that you can be discriminated against, the protected characteristics, essentially?
Yeah, absolutely. Because I always make an assumption that when we're talking about discrimination, we're talking about not treating a job applicant less favourably because of a protected characteristic. That's the definition of discrimination. And by a protected characteristic, we mean in a characteristic that's either related to somebody's age, to a disability. Oh, I'm going to get tested here. There's 9. So age, disability, gender reassignment, sex, marriage and civil partnership, protected beliefs, race, religion. Oh, and there's one more. Did I say age?
Yeah.
It'll come back to me. Anyway, it's not important. It is important. But it's not important. Let's edit that.
Whoever's that last ninth protected characteristic is literally crying inside.
Okay, all right, it'll come to me. Yes, so that's what we mean by protected characteristics. And when the other one comes back to me, sexual orientation. Actually, hold on, there's also maternity and pregnancy. I
think you've definitely got all of them.
Fine.
Don't panic. Right, someone tell us if we've missed it.
So that's what we mean by a protected characteristic. And discriminatory behaviour or actions or decisions that an employer can make can be quite obvious. And sometimes it's a case of the employer doesn't know what they don't know. Mm-hmm. Discrimination can be direct and indirect is probably a better way of putting it. So by that I mean, if you make a decision not to offer a job to a woman because you run an all-man's a team that's made up of all male, then that would be quite an audacious discriminatory decision, right? That's direct discrimination. Indirect discrimination might be, however, something like deciding that you are going to hold interviews in person in a non-accessible building. So a wheelchair user who's a job applicant couldn't access it, and not making a reasonable adjustment. So, for example, allowing the interview to take place online as an alternative to enable them to still access that part of the assessment process. So we're talking about direct and indirect actions that could be potentially discriminatory. And when we talk about recruitment, it's not just a big mesh. It's a staged process.
Yeah.
Okay. And like you said, so we've got those three kind of stages. Let's look at them. So the terms by which somebody might be offered a role, which you might think is at the end of the process. No. But actually, if you get it right, as we do in our recruitment drives, we define those from the outset.
Yeah, absolutely. Yeah.
So we challenge a client to really think about what are the terms, have they defined the role? Do they know what they need in terms of both that technical skill set and that behavioural skill set, which we talked about a lot in the last podcast, but also what are the key terms by which they're contracting? So by that we mean, what's the weekly working pattern that they need to work? Are there set hours? What are those working hours and why do they need to be when they are? What is the salary for the role? Where is the work going to be done? Where is the job located? And all of those decisions need to be made quite carefully in line with genuine business need. If for example, a job was advertised as being office-based, an employer might come under scrutiny by an employee who can do that role, can do it adequately, but would need to do it remotely because they're not close in proximity to where that office is based, and may, for example, if it was a female, may well allege sex discrimination indirectly on the basis that she has childcare support needs, and this could apply to a male as well, of course. And as a result, he or she wouldn't be able to fulfil them if they had to come into the office. So employers have to be really, really careful around deciding what those key contracting terms are and being able to justify them under a business rationale if they were ever called into scrutiny.
We talked about that a little bit on the flexible working podcast as well, wasn't it? When people sort of say it has to be office based, not just from a cultural, practical, how likely am I going to be to appoint to this role, but also importantly, potentially it could be indirectly discriminatory to make that decision. No, I don't think people will think about that when they're scoping their roles. Understandably, busy people trying to get roles out, but actually each one of the terms that they're advertising under, you're saying you need to really look at it and say, why am I doing it like this? What is my rationale? Is it a genuine business need? And who might I exclude from the process if I put this down, if it's not a genuine, legitimate business need? I really like the example as well of having somebody that might need to have a start and finish time differ because they have caring requirements or childcare requirements as well. That's a really interesting example of if you don't need to be in the office at 8 and you could be in at 9:30, that opens up the field to more people, which has got to be a good thing, but it's also not discriminatory, which is hugely important.
Absolutely. So it's not just a compliance exercise and getting it right from a legal safety perspective. It's also like you said, who do I not know that I'm excluding by setting terms too tightly if I don't need to? So that's the scope, what we call the scoping stage, right? When you're defining the role itself and the terms of it. Then there's the second stage of that, which is the advertising of the role. So the advert that should go with the job description. And we see some crackers, don't we?
Stinkers.
I'm part of a few we're part of a few HR forums where HR consultants around the country will just take pictures of adverts that they see on shopfronts and things and put them on, mainly for the lulz. But I think the latest one was a strapping lad required for labourer role. Can't be woke. I remember there was definitely a woke reference.
Can't be woke. How do you assess that?
Basically.
Don't answer that.
So you do see those kind of audacious examples, but I think, again, even if you're being quite conscientious, there's still language that you can use and phrases that you can adopt in adverts that can be inherently discriminatory, but on a more nuanced level. So asking for a mature person may well be indirectly age discriminatory. Asking for somebody with 10 years experience will have the same effect, because ultimately a 22-year-old applying for the job is unlikely to be able to demonstrate 10 years worth of work experience.
That one shocks people. And I see that because I think that was traditionally, and we're going back 10, 20 years or so, that was standard for a person's specification to say, these are the years of experience, qualifying experience I want, 5+ years, and these are the level of qualifications that I want. And that was an interesting one as well.
Absolutely. Qualifications is another thing. It's another one. Why do you need the qualification? Obviously, if you're talking about the legal profession or
surgeons.
Surgery, yeah, we'll teach you on the job. That'll be fine. Yeah. You're absolutely right. There are absolutely jobs that require very clear qualifications. But where a job doesn't require it, for example, you see quite a lot degree equivalent, degree qualification essential. Why? I bet people with degrees that have far less common sense than people that without them. So what is that an indicator of? Why is that essential? And being able to really be able to justify that if you are asked that question, and what could you put in to suggest that other demonstrable experience might be just as worthwhile or considered as a way of mitigating that type of strict criteria. So there are elements of the job advert and the way the way the role is described and the way the person that's being looked for, or ideal candidate for the role, is being described. Another one around confidence. You've got to be confident. You've got to be assertive. Part of a work hard, play hard culture. I mean, that's the cultural elements of it. So in that type of instance, work hard, play hard, that would appeal to more of a young person that is free of other responsibilities. It's not necessarily going to sound attractive to somebody with perhaps learning disabilities, where perhaps they need more of a slower pace to be able to undertake their work. And that's a stereotype, but that's one that's come up in a previous case that we've had. You can use masculine language by, like I said, the confidence, looking for someone that's confident, that's assertive. It's a minefield.
I think one of the ones that really sat with me, and we were at an away day, I think we were facilitating a away day a while ago, and one of the employees who had come from Brazil, I think he'd settled in the UK for probably around about 5 or 6 years, said that when he came to this country, one of the things he really struggled with was the fact that his university education and his professional qualifications were, from his perspective, basically worthless in recruitment. And I think that was a real, for someone with my privilege, that was a really interesting and saddening thing to hear, that actually you can work and really hard to gain professional qualifications, but actually if you are seeing adverts where it is a degree or it is a certain professional qualification and there's no equivalence mentioned, then that really can be quite excluding and discriminatory outwardly. And I think the other thing, I will often talk about having generalized anxiety disorder. If I were to see an advert that said must be confident under pressure, work in a fast-paced environment, able to handle a stressful workload, I'd think, no, thank you. But I probably have a resilience to stress levels, unlike most people, in terms of how much I can take on, but it does immediately put people off, and it can be discriminatory.
Yeah, absolutely. So at this point, we're just up to the point where we're advertising the role. Then there's the application stage. So how somebody applies or submits an expression of interest for the role. And we've seen all sorts in terms of the questions that get asked and the types of things the information that's requested on an application form, for example, date of birth, marital status, sick records. Why? If you're asking for that information before you've made a decision as to whether that candidate is likely to be successful for the role, you are opening yourself up to the inference that information became part of your decision making criteria. So my advice would always be never put it in an application form. So that's where you can fall short in the application stage. Then there's the assessment process, right? Whatever stage of that we're talking about, whether it's sifting, whether it's pre-screening, it's interviewing, whether it's doing some sort of exercise or assessment centre. The assessment stage is probably rife with potential risks. And that probably starts from an accessibility perspective. So how are you assessing? Is, as I use the example, if it's an interview, is it going to be in person or is it going to be virtual? If somebody, for whatever reason, by way of a reasonable adjustment, needs it to be in person, if it's virtual, are you going to make that allowance? If they need it to be virtual instead of in person, again, are you going to flex up? The assessment requires some sort of test or skill, filling in a spreadsheet or conducting a presentation. Are you prepared to give somebody that processes slower a longer period of time to be able to complete that exercise? For somebody with autism, for example, are you going to ensure that they are able to have the questions in advance if that's what they ask for by way of a reasonable adjustment? It's about making sure that at that application stage, whatever that looks like, you have made very, very clear to potential candidates that if they have any sort of support needs or reasonable adjustments to be able to access and take part in the assessment stage, that they let you know what they are up front and that you are prepared to accommodate them.
And it's really easy. I mean, it's not difficult, because actually we're using examples, but like you're always the first one to say we don't make assumptions. So it's about knowing, when you design your process, one, right from the beginning, why you're making the decisions you're making in relation to terms. But then we spoke about on our previous podcast that recruitment processes need to deliver an excellent candidate experience. Part of delivering an excellent candidate experience is saying, we want to hear from you. And then at the point that we hear from you, this is the process you're going to go through. And if they are applying via something like Indeed, or whether you have your own applicant tracking system, and we're big fans of Hireful here, that the email that they get back, whether it's something you set up automatically or whether you've got somebody sitting there fielding them, or whether it's just a case that you're collecting expressions of interest into an inbox, that the message that goes back is inclusive and says, this is our process. If you require anything adjusted, please let us know what that is so that we can support. It's kind of just kindness in a way, and inclusivity, isn't it? And it's really easy. It's as simple as that. We're not saying that our small business employers have to become experts in every condition and foresee what adjustments might be needed. We're saying open yourself up to the possibility that they might be, and welcome it, because you're better off inviting that conversation in and then being able to look at what's reasonable and what you can accommodate, than making decisions and then perhaps facing a challenge later on. And those challenges do come, even for us.
Yeah, absolutely. We had one a couple of weeks ago, didn't we? And I mean, that for us wasn't a reasonable challenge, and that's the other side of the coin, right? There will be times where you get requests that you just can't cater for them, and it's not reasonable to expect you to. It's just about creating a level playing field and a reasonable expectation on you as an employer to do that.
Yeah.
So it's got to be proportionate, and it's got to make sense.
And I think with discrimination, one of the things that we often talk about in our training is that actually the biggest risk is your own bias, especially when it's on an unconscious level. So we've talked about, adjustments and creating a level playing field and making sure that people can take part in your process and in your assessment. But there's also what's going on behind the scenes that the candidates are never exposed to. So the process by which you decide a CV is going through to the yes pile rather than the no pile. We see these awful situations. We've got evidence, again, there's been plenty of research that when we have diverse names, they can more often find themselves in the no pile than in the yes pile. That's because of bias.
And I'm not sure that's unconscious. I think that's conscious bias.
Yeah. Some, as I say, conscious and unconscious, and it really depends, doesn't it? But we absolutely know that happens, consciously or unconsciously, sadly. And I think that it's about checking that your process challenges those biases, conscious or unconscious. I mean, conscious is easier because you're doing it. You're aware that you're making decisions not to put people through with gaps in employment or not to progress women in their 20s because you're worried they're going to go off on maternity leave, or
asking questions around to a female candidate with children, how they're going to cope.
Yeah.
That's come up recently a lot. You're right. They are very conscious bias mindsets, right? But you're right. There's more subliminal bias as well.
We know it's a lot more nuanced than that, and it's about having enough diversity and enough awareness of your own decision making to be able to challenge it. And if you aren't able to do that, to be able to put measures in place to do it for you. So we know that when you're using something like an applicant tracking system, and go back to Hireful because it's so affordable and so easy to use, we can put steps in place to make sure that we take names off CVs and that we anonymize certain aspects of the application so that people's bias isn't allowed to play out, conscious or unconsciously. So there are things that you can do to challenge your unconscious bias, making sure that you have a range of different people in the process at a range of different stages, so that you're challenging each other, thinking about the thought process that you're using and making it more objective when it comes to actual criteria for putting a CV through from the shortlisting stage. We often say shortlisting is just about narrowing the field. It's not about hiring someone. So what is the essential criteria, objective criteria that you're using, and make sure that's applied across the board. And doing the same thing with interview. Just doing that little bit of thinking brings the unconscious into conscious, so you can challenge it.
Absolutely. And all of those things are going to keep you, whether you care about it because you're an ethical and a moral person or not.
Just a decent human being.
Yeah, absolutely. If you don't care about those things from that perspective, care about them because it's going to keep you legally safe.
Yeah.
And you're going to be able to defend yourself in the event of a legal challenge. But discrimination isn't only the legal risk in recruitment. There's a few others as well, like I pertained to at the beginning. Things like data protection, that's an inherent part of the management of both employee and job applicant job documentation and personal details. So you have obligations under the Data Protection Act to ensure that you are storing and processing job applicants' information in a secure and safe way, that you're not retaining it for longer than you need to. So we've probably all worked with those employers that are like, I quite liked them, but although they're not going to be offered the job this time, I'm going to keep them for 9 months because we might have a job come up then. Get the candidate's permission to hold on to that CV, please, for God's sake. So ensuring that you're really clear around what your privacy policy or your retention policy, if you've got one, says around how long you can keep job applicant data for. That's a key one. So it's not about securely processing it, it's also about how you retain it and how long you retain it for. So there's data protection considerations. It's more than that, but I'm not a data protection expert, don't profess to be one. Then there is considerations around right to work checks. How many clients do we go into where they haven't proactively, before somebody starts a job, obtained their right to work documentation? And by all means, please don't. I've also seen clients that have only gathered it when they don't think that the person is white and British born.
Yeah. They look white. No.
They're white and they're British. And I was like, okay. I mean, gather it for everybody.
Yes.
That's your legal obligation. Don't make assumptions. So right to work checks, that's really, really key. If you knowingly employ somebody that doesn't have the right to work, there's a costly fine in it. I think it's £20,000. I could be wrong. Correct me if I'm wrong. Not you, the audience. I know you don't know. Ain't got a clue. Safeguarding, that's another one that comes up if you're employing a role that works in regulated activity. So by that we mean working with children and vulnerable adults directly. There are safer recruitment principles to work to, right? And what's the other one? DBS checks, yeah. Making sure that you've conducted DBS checks and have got that clearance before somebody starts a job. So yes, so when you're employing somebody to work in regulated activity, you've got enhanced obligations under safeguarding laws. And then contractual, like offer letters. I know you know quite a lot about this because I harp on about it. So, like, conditionality of offer letters. And that's a really, really key thing. And that's something that we don't find that employers always understand.
Yeah.
And that's about when you're about to make a verbal offer or a written offer for a job role, making sure that when you're putting it in writing, the conditionality of that offer is dependent on a certain number of prerequisite requirements. So whether that is passing a DBS check, whether that's satisfactory references coming back, whether that's right to work documentation, whatever those conditions are that you set, list them in the offer letter. Make really, really clear that the offer could be withdrawn if these preconditions are not satisfied. Because if you don't, you've already entered into a legally binding contract. So then if you decide to withdraw the offer, a savvy job applicant who understands their employment law rights is going to assert that you owe them a notice period.
Yeah, I always find that shocking, and I remember a number of clients being really shocked saying, well, hold on a sec, I have to pay notice to someone that never actually started. It's like, you've got 4 weeks notice in your contract. You sent them the contract instead of a conditional offer letter. They signed it. You owe them notice if you want to change your mind now. And they can't believe it.
Yeah, it's mind-boggling.
Yeah.
But yeah, and we do see clients pull foul of it. So there's the contractual law element side of things as well. So yeah, that's probably my summary of all the kind of legal considerations that can come up during the recruitment process and the offering process.
And I think that's really helpful because as I said at the beginning, I think there are a number of there's a number of business owners or founder managers who think it's just recruitment, I can do this, and it's absolutely not one of the risky areas of bringing people into my business. I think what we're saying is it is, but it's also about awareness and knowing what those risks are. It's not trying to put the wind up people so they never want to do it again. Yes, there are plenty of people like us that manage recruitment drives, and we do that for a reason because it is a specialist skill set in all sorts of areas, not least because of the levels of legal risk, as well as all the other pitfalls we've talked about on previous podcasts. But also it's about saying, okay, well, what are those risks and how do I manage them? It's like any risk, isn't it? And there are some simple steps. One, you could get advice or get someone to do it for you, of course. But there are also a number of ways you can use AI. We haven't talked about AI, and I think it's probably quite important that using AI as part of a shortlisting, sifting, assessment process can also be fraught with risk.
We missed that out of that part, didn't we? And I think that's probably worth revisiting because you're right. Even when you're quite a progressive thinking business or manager or owner, and you use AI to support with different elements of the recruitment process, usually at the assessment stage, AI could be biased. And that's concerning, right? And not a lot of our clients are aware of that. AI perpetuates historic data.
So it carries the bias of centuries, which makes it inherently flawed. So yes, we need to be mindful of AI as a decision-making tool and as an assessment tool, but what we can do is use AI to scope and look at our job descriptions. And that's one of the things I think is really good. And also to analyze objectively your documentation around your adverts for any bias risks, any gendered language, any exclusionary language that could upset anybody from any walk of life, especially in relation to a protected characteristics. But that's where our AI is your friend, because it could be a critical friend as long as you write the right prompt. And then I think as well, just understanding that it's about being open to people asking for reasonable adjustments and perhaps trying to have a mindset that that's a good thing. Because actually, if you've got an assessment process and a recruitment process that invites people to feel psychologically safe enough to tell you that they need some adjustments, then you're finding that out in a really good way, in a managed way at the beginning, and helping to make those adjustments starts the relationship on a really good footing. Yeah. And I've seen it work so well. And these adjustments can be really simple. I think gone are the days of setting people up to fail as part of an assessment process. I think historically we were all saying, well, if they can cope with the pressure of an interview and how do they do, and let's not tell them about this thing. And actually, surely we're setting people up for success so that they can take part and show you all the reasons why they'd be a fantastic employee.
Yeah. And like I said, you're going to care about that if you're a really decent human being with a really good moral compass. Either way, if you're not, strategically, from a reputational perspective, it's a really smart thing to do.
Yeah.
And that's the cynical.
I know.
That's the cynic in me coming out.
I'd like to think that all employers think in the former, but there we are.
I know you do. What a way to end.
I know. So that's it for this week. Don't forget to subscribe so you never miss an episode. Share this podcast with your network and follow us on our socials at PIAP Consulting.
Join us for next time. And until then, remember, people problems don't fix themselves.
And healthy cultures never happen by accident.
See you next Tuesday.